Good afternoon and welcome to the Danna-Gracey and Acevedo Consulting webinar, HIPAA, how to avoid becoming a worst case scenario. I'd like to turn the reins over to Matt Gracey, who is the CEO of Danna-Gracey, which is the leading independent medical malpractice insurance agency in Florida. And Matt, take it away.
Thank you, Wendy. We are so pleased to be here today and have so many of you join us. I think my first order of business would be to congratulate you on not taking an ostrich approach to this topic, because I think we're seeing in the marketplace exactly, what happens when an ostrich approach is taken, and you're going to hear today from our experts that things are really happening right around us to your peers, and it's really time to pay attention, as we know, to this some of the HIPAA issues that are now exploding even locally. So with that, I am very pleased to present Catherine Becker. She's of Acevedo Consulting. They have been a long-time ally of ours in Danna-Gracey. We happen to share the same town as our corporate headquarters. They're just across town here in Delray Beach, Florida, and we have known the firm for years and have highly respected the Acevedo folks. And Catherine is just a superb speaker and a wonderful knowledge source on this topic. Tom Murphy is going to then come in after Catherine. He is one of our experts here at Danna-Gracey on this subject, and he's going to tell you a little bit very briefly at the end about how you can mitigate some of this risk with some insurance coverage help. So with that, Catherine, I turn it over to you.
Thank you. All right, so we really do appreciate everyone logging in today and participating because HIPAA really is a big deal in the healthcare community. The government is taking this very, very seriously, so we want to make sure that everybody is prepared and how we can avoid you becoming one of the stories that I tell at future webinars. So I'm going to start with something that sounds very, very basic, but I can't explain to you how often I find the answer to my next few questions is not correct. So do you have policies? If any of you are listening today and you don't have a HIPAA manual with your policies, you need to get one. Make sure that you have one, because as you'll see as I go through these examples today, one of the first things that gets asked when you are having to go through an investigation is they'll ask to see copies of your policies. So that is step number one. If you don't have them, you need to get them. If you do have policies, when was the last time that you read them? Because it's really important to make sure that what you're doing matches your policies. Because as I said, they're going to ask to see your policies, and it's all well and good to send them a copy of your policies, but what you've actually been doing in practice is not the same. It's not going to work for you. Then you technically didn't have a policy if you weren't bothering to follow it. But then I also want you to think, well, are you training your staff on your policies? HIPAA training is one of those things that should be happening on a yearly basis. And one of the things that I know has become popular is to just find HIPAA videos that are on the internet, or there are services that will just offer something like that. But it's really important to know that you don't just have to have your staff trained on what is HIPAA. They need to be trained on your particular policies. And as you'll see as we go through some of these examples today, people can have different policies. There are parts of HIPAA that are always going to be the same. The time frame that you have to fill a patient's record request. But there are other things that can be altered on a practice-by-practice basis. So if you're just getting a generic training off of the web, you're not going to have the same protection because you haven't actually trained your staff on your policies. You've just given them general HIPAA guidelines, so that won't work. So I'm going to start with a complaint that we had last December that came up for one of the practices that we work with. The patient had requested their X-ray records from an orthopedic practice and was told there would be a $15 fee for that request. The patient complained to the practice because she felt this was too much to pay. And according to this patient, she did not receive a response from the practice. Due to that, she filed a complaint with the Office of Civil Rights. The Office of Civil Rights is the government entity that deals with HIPAA. And so this is one patient making a complaint. And I want you to think about, do you think we've heard about this from the Office of Civil Rights? And the answer to this one is yes, we have, which is something a lot of people wouldn't expect, that one patient writing a letter could prompt a government investigation, but it sure did. And so where this came in was going down to patient record fees. The practice received a request asking for their policies on record requests for their patients, but we also had to justify what they were trying to charge. We had to explain where those fees were coming from. And this is something that we went back and forth on quite a bit. The practice originally had a higher fee, and the government told us that it was not what was considered reasonable. And then we literally had to break down where we were coming up with the fees, down to the CD that the x-ray was going on, envelope, shipping, all of that kind of stuff. So the questions you want to be looking at here: are you charging your patients for copies of their medical records? One of the things that I started doing after this came up with the client was to start asking other practices, were they charging their patients, and what were they charging their patients? And I was actually quite surprised to find out that the majority of practices were not charging their patients anything for their records. But for those of you who may be doing this, you want to make sure that you have documented what you're charging and how you got there. And do you have different types of fees for these kinds of records? Paper records versus electronic records, or what they consider special records, which are the x-rays, MRIs, things that you may be giving them on a CD. But you also want to make sure that you have your fees published in your notice of privacy practices, any record request forms that you may have, as well as on your website. If you include intake paperwork on your website, that is another place where we had to have it posted for the Office of Civil Rights in order to clear this particular situation. And the Office of Civil Rights is taking a big interest in patient access to their records this year. So while this may seem like something that's fairly benign, this is a really big focal point for the Office of Civil Rights this year. So you really want to take the opportunity to make sure that you have this being done in your practice appropriately, because for this particular practice, they did not pay any type of penalty. We were able to get everything settled. But I think part of that was because they were the first case to go in. I can't promise that would be the same result for everyone. So make sure that you do go and look at how you are treating your patient records. And one important note is you cannot charge patients for retrieving their records through the patient portal. That's because of the fact that you're required to have that portal if you are testing to meaningful use. And you want to make sure your portal works. This is something that's come up a number of times where our practices say, well, we could give it to the patients through the portal, but it doesn't actually work. If you are attesting to meaningful use, you've been attesting that you have a patient portal and it works. So this is one of those sticky situations where you could have one problem multiply on you, where if a patient's filing a complaint about their medical records and the portal, where then if you've been receiving meaningful use money, you could have the government coming after you in another way because of the fact that you've potentially been receiving incentive money that you did not earn. So please keep those things in mind. So make sure you review your policy. Make sure that you can justify what you are charging if you are. You're allowed to use an average cost, but it must be reasonable. And what that means is if typically you're mailing your patients their paper records, come up with the average cost of postage. You can't choose the most expensive method. So if 1 in 100 patients ask you to send something to them by FedEx, you can't use the price for overnight FedEx in your average cost. You need to use the methods that's typically used. And so for those of you who may be having to go back and look at these and make some changes, make sure that you're updating all of your relevant policies or signs, because I know very often practices will have signs posted in their waiting rooms about how much they're charging for records and things like that. And you want to make sure that it is changed across the board. So my next example is another one of our clients here locally. He had gotten really behind on his dictation, and he has a deal with his practice manager that he never gets more than 6 months behind on his dictation. And I'm truly hoping that none of you who are logged in here with us today can relate to that particular situation. But so nonetheless, he was getting ready to go on vacation, and his manager reminded him that he was going to owe her for February, and it was now going on August. And he said, don't you worry about it. I'm going to take everything with me, and I'll get caught up while I'm on vacation. So he threw all of his surgical face sheets in a briefcase, and off he went on vacation with his family. While they were on vacation, his car got broken into. Every iPad, iPod, phone was stolen, in addition to his briefcase. The briefcase was never recovered. So we had to treat this as a breach because we could not determine what happened to the information. No, somebody popped open the briefcase and found that it was just paper and not worth anything and just threw it in a garbage can. But we can't prove that. So we had to treat it as a breach, which meant that we had to go back and account for all the patients that he possibly could have had on him, and then figure out what information had possibly been exposed, because some hospitals included full Social Security numbers while others did not. We reported this breach to the Office of Civil Rights in January of 2015. Unlike our one patient complaining that I gave you in our first example, we have yet to hear from the Office of Civil Rights on this one, which may surprise a lot of people, because you would think that after losing over 100 patients' information, there might be some urgency there on the part of the Office of Civil Rights. Now, just because we have not yet heard from them doesn't mean that we won't. It just means that this one is still going on. But the lessons to learn from this are to think about, where are your records, whether it's paper records, electronic records, and where are they traveling to? For those of you, I know a lot of people have the tablets and the laptops that they're using in their practice. Is the information actually sitting on that hardware, or are you using a remote desktop type situation? Those are important questions you want to know, because this is a really big risk for practices. Under the HIPAA rules, you can be fined anywhere from $100 per patient up to $50,000 per patient. And that's one of those things you really want to be aware of. Those fines can add up quite quickly, and that's something I think that Tom will talk to you about later when we get into the insurance side of things. But so, as you can imagine, in the old days, it would be really hard to rack up a lot of fines because you weren't running around with hundreds of paper files on you. But in this day, if somebody's running around with an unencrypted laptop, or if they're downloading patient information to a thumb drive that's unencrypted, it would be very easy for a lot of patient information to be sitting on those devices. So you want to be very, very careful and think about that. Think about who on your staff has access to PHI, and is it leaving the office with them? If you have people who are leaving with laptops, thumb drives, external hard drives, things that may have PHI on it, are those devices encrypted? Under HIPAA, if the device is encrypted, you don't have to treat it as a breach. Whereas in this example, with that briefcase being gone and we were never able to determine what happened to it, we had to go with the assumption that the information had been breached. That is the way that the HIPAA rules work. So I can't express to you how much benefit there is to making sure that any device that has PHI residing on it be encrypted. I know it's not always fun, but it is something that you do want to be aware of. And this includes mobile devices such as cell phones. So if you have providers in your office who are potentially texting each other or emailing, you want to make sure that those devices are encrypted. But as I said, also think about who's allowed to have that PHI. This is something you really want to think about, and make sure that your policy is known. This is where I was talking about. You want to make sure you're training your staff. I was going through and doing a security risk analysis with a practice, and we were discussing who on staff had access to PHI through their phones, and they were telling, oh, it's just the doctors, it's just the doctors. But we happened to be close to the front desk, and the girl at the front desk said, well, I get my email on my phone. It was not something the practice had ever told her she was allowed to do, but she had just gone ahead and done it. She had set herself up to get all of her work emails sent to her phone. Now, this is someone whose sole job is to sit at the front desk and answer the phone. She's not somebody who runs between practices. She's not somebody who's expected to do work after hours where she would need to have that access. So this was a big moment of shock for that practice to realize that they needed to go back and make sure that if it was possible for them to turn that feature off, that would allow staff members who didn't need access to add the emails to their phone, but also train their staff so that even if it couldn't be stopped, they had trained their staff that they were not allowed to have that on their devices unless it had been approved by the administration. So that's one of the things you also want to think about. One of the great things about electronics is it makes things really easy. The downside of that is that it is sometimes too easy, where things are happening without you even being aware of it. Another thing to think about is, do you have people who have remote access to your PHI, and do you have ways to control that? A lot of people are now on cloud-based solutions, but you want to think about, does everybody need to be able to sign on remotely? I have practices where it is possible within their EHR to put time limits on it so that their employees can only log in from, let's say 8 o'clock in the morning to 6 o'clock at night. But they can make exceptions where the providers who are on call have 24-hour access. But people who don't need to have access beyond the office hours, if they were to try to log in at night from home, it would not work. So those are the kinds of things you want to think about, because that PHI, how it travels, how it can be saved, is a really big deal, and those are things you want to think about in your practice because it is such a risk. So you want to make sure that where you can contain that risk, that you really have. And again, do you have policies? And that's one of the things we find is often lacking for people, is that they don't have policies that contemplate these kinds of decisions, because this is where you would have to defend yourself in the event of a breach. Is what did you have in place? And it's not that nothing ever goes wrong when you have a policy, but you'll want to at least be showing that you were trying to do the right thing, because HIPAA is a good faith-based rule. So at least you were intending to do good, but it's a lot harder when you don't even have a policy to stand by. So now we have another patient complaint. This was where we had a practice that sent out an email to all of their patients letting them know that they were no longer going to be accepting Blue Cross Blue Shield. The person in the practice who sent out the email forgot to put the patients on a blind copy. So the entire contact was visible to all recipients. The patient contacted the practice, was very, very upset, and then because of the fact that they were not satisfied with the practice's response, they also complained to the state attorney's office. And in this situation, the state attorney's office was happy to get involved and respond. They've let this practice know that they are being watched. They did not receive any type of fine. In this situation, it was not actually a breach because the email was vague in nature. It was just about the fact that the practice was no longer accepting this type of insurance. It did not, there was nothing about the practice that was sensitive. For instance, the emails were not coming from an AIDS clinic or an abortion clinic, something where there might be some sort of stigma attached by you being on their mailing list. It was a general practice. So there was nothing that was considered sensitive to this. But the state attorney's office did let the practice know that they're kind of being watched now. If there should be another complaint, that they will take more of an interest in this situation. So, and this also shows you there's more than one entity that patients can reach out to if they have a concern. So in this situation I want to talk to you about is make sure your staff are trained on how they should handle patients' complaints, whether they're expressed verbally or in writing. Who handles your complaints? Make sure your staff knows that. Is that something that if a patient's complaining, the person who is hearing the complaint should be trying to handle on their own? Or should they be getting someone else involved, a manager, one of the physicians, to make sure that this situation is handled appropriately? But you also want to have a system in place for how those complaints are documented. Is it going into the patient's chart, which is obviously highly recommended, but I also recommend that people have a central complaint file. Because the example I gave you in the beginning, that was about how much the practice was charging the patient for their records. At no time during that investigation would the Office of Civil Rights tell us who the complaining patient was. We were requested to give up the policies, but we could not defend the practice from the stance that they had complied with their complaint policy because of the fact that we were never told who that patient was. Now, we were told about the time that the complaint was stemming from, but because this particular practice did not have that central complaint file, we did not have a list to go back and refer to. The only way we would have found out if something was documented in the patient's file was by knowing that patient's name. So that's why I recommend having that dual system. Obviously, make sure you do have it in the patient's chart, but for administrative purposes, I also recommend having a central list so that if you do receive one of those letters, you have a way to try to go back and track what was done. My next example is another one of our practices that we work with. The patient had emailed the doctor asking for his medical records to be either mailed or sent via FedEx. And the patient says in the email that the office offered to fax him the records, but he does not want them faxed as he shares the fax machine with his entire office. And he could not have been more clear about this. He even stated in the email that it would be a HIPAA violation for his records to be sent to him via fax. Unfortunately, this information was lost somehow in communication with the staff who actually provided the records, and the patient did receive his records via fax and from multiple people in his office. So this was a big deal, because this wasn't just a whoops. This was a fact that the patient had already been very clear on what he wanted and had told them that there would be a problem if they did not comply with this. So this comes down to looking at, in your practice, how are record requests handled? Do you have one person who's handling those record requests? Is it just whoever is asked for the records fills it out? I highly recommend having a central person who handles your records request, because there is a bit of an art there. It seems like it would be pretty simple. But in fact, there is a lot that you need to look at when you're getting a record request. It's different if it's just the patient who's asking, but you get lots of requests that will come in from other doctors' offices, and maybe from attorneys, from insurance companies. And you need to know that the person who's looking at these requests knows what information should be there, but is also going to take the time to make sure that any requests that are in there for the method of communication are being adhered to. You also want to look at how do you send record requests, because there are a number of ways in which you can do that. There's mail, there's email, fax, or is the person coming in to pick it up? And you also want to make sure that you're documenting how these record requests are coming through. Is it something that the patient has written out, or is this a verbal request that you've gotten? Documentation in these situations is really, really important. I will give you an example of a client we had in the Boca area who the patient went in but just felt like they didn't really get a good service. They were sort of ignored. They sat in a waiting room too long. But there's not really anybody to call and complain about something of that nature. But what she did do was contact the state attorney's office and complain that the practice was not giving her her medical records, which she knew would get them in trouble. The practice received a letter from the state attorney's office requesting, again, their policies and a number of other things that went with it. And the office manager in this situation, she panicked. She didn't know what to do. So she called the state attorney's office and asked for help and said, can you please explain to me what is going on? And now I promise you this is something that would almost never happen again. The state attorney's office actually told her who the patient was. And that practice was able to go pull that patient's chart and show every single time the patient had requested her records and every single time they had filled that record request. And based on the fact that they had such good documentation and were able to show what they had been doing, the state attorney's office said, thank you and have a nice day. You can disregard the letter that we've sent you. So again, while record requests may seem like sort of a benign item, it is one of the areas where we see a lot of drama around it. One, because it's how patients are interacting with other physicians, and if you don't have people who are handling those requests appropriately, it may be impacting how the patient is able to see other providers. But also if you have people who are being sloppy in how they're delivering these records, this is where you find yourself in a situation like this where you've now got a patient who is irate because their records have been faxed to their place of business and their coworkers are removing their medical records from the fax machine, which is not a situation that you obviously want to have. Email is a really important point that I want to discuss with you. One of the things that came with this situation where the patient received his records via fax, while we were first addressing the fact that the medical records were not sent the way that the patient had requested, the other issue that came up was the fact that the doctor was communicating with the patient via email. This was a practice that I had done their security risk analysis probably not 6 to 8 months before this. And one of the questions when you're doing a security risk analysis is whether or not the practice communicates with patients via email. And I had been told at the time, and very emphatically, no, this was not happening. So that was my second line of questioning for the practice is, how is it for a practice that's not supposed to be emailing with patients? We now had a situation where this was all stemming from emails between the patient and the physician. That's why I want to go into this with you, because email is very popular at this point in time, and I want you to understand it's not that you can't email with patients, but you do need to think about how it's going to be done and who's doing it. So the Office of Civil Rights, when they released their information this year on how much you can charge patients, they also had a lot in there about patients having the right to get their records via email. It's obviously a very popular form of communication these days, but there are rules in place for this. You must warn patients if they're asking you for their records via email that it's not a secure form of communication. That's very, very important. If I'm asking you to send me my medical records to my Gmail account, there are all kinds of things that could happen. Somebody could intercept the email as somebody who has their email set up to go to their phone, to a tablet, all of these different places. My medical records could be ending up in more than one spot. So that's something that you want to think about. And if the patient accepts the risk, then you must comply. So if I, as a patient, after you've given me all of those warnings, I say, I don't care, please still send it to me, then you can send the patient their records wherever they've asked for them. I say that this should always, always, always be in writing. I've had practices who will say, well, we got an email requesting that we respond with their records. I always ask them, how do you know who the person is at the other end of that email? Now, sometimes you've got somebody who has an email address. For instance, mine here at work is kbecker@acevatoconsulting.com. So the likelihood that it's me is probably pretty good, but it's still something where you would want that patient to have put it in writing, because very often when you're dealing with patients and Gmails and AOLs and all of those kinds of accounts, it's something like Tennis Pro 123. You have no way of knowing who that person is that's sending you that email. Not to mention, you don't know if it's a shared email account. Very often there may be spouses or families who share one email account, so you don't know that it's actually the patient who has emailed you and asked you for something. It may be their spouse or a family member who has access to that email account. So that's why you want to have something in writing from the patient that, one, goes over all those disclosures about why email may not be the most secure form of communication, but then have the patient signing off on it, including writing out the email address where they want those records sent, so that you have that in your file, so that should something ever go wrong, you show that you have done what you needed to do to make sure that the patient was aware of it and that you had permission to do it. And it doesn't mean that the patient can never take away that permission. It just means that anything you've done up until they do remove that permission is protected. So the warnings that I will give you with this, because as I said, it comes up quite frequently. This should be a very controlled form of access. Not everyone in your practice should have the ability to email patients, because when you get too comfortable with that email, because we all do communicate so much via email now, it gets much harder to keep track of who is doing what, but you also lose some of that formality. If you're having too much emailing going on with the patients, you may have patient care that's going on outside of your medical record. And that's something that you want to be very careful about, is making sure that any communications that are happening through the appropriate channels. So if everybody in the office is able to email, you may lose some of that. Never let your employees send patients their records from their own personal email accounts. This is something that came up for one of the practices that we work with. They were emailing patients their records, but they didn't have a corporate email address set up. So the office manager at the time was just using her own Gmail account. She figured, I have access, not a problem. The problem with that is, if you have employees who are using their own personal email accounts, you don't control those email accounts. If that person quits tomorrow you don't have access to what they've been up to. So if you have a patient a week from now, 6 months from now, who's complaining about the fact that they received records via email, you have no way to go back and verify what was sent. Was it sent? So make sure that you do not have anybody using their own personal email accounts to send any of your records. If you need to set up a corporate email account, there are a number of different services that allow this. And make sure that somebody, whether it's a doctor, an administrator, they maintain control of the account, so that you may give somebody access to use it, but that is not a person who has the authority to change the settings on the account. Because we have had a practice that had somebody who had access to the patient databases and things like that, but they maintained control of the account, not the physicians. And when that person decided to leave, they locked out the physician. And the physician did not have access to any of their own information. So it's really important that you do put controls in here so that no matter what happens from an employment standpoint, the practice has the ability to see what was being done, and they have that ability to show something for it. And I would also recommend auditing this particular feature very heavily. Make sure that patients who have received their PHI via email have that corresponding request in their chart. And this is something that I can't stress highly enough, particularly if it's a new behavior, because like I said, the Office of Civil Rights is really stressing that at this point, if the patient wants their records via email, there's no reason you shouldn't be doing it. But like I said, that does not alleviate you from having to make sure that the patient understands the risks of that. So you want to make sure that for every patient that there is a corresponding request in their chart. So if you're allowing other people to do this, you want to make sure that you are going behind them and confirming that this is being done. You don't want this to be the kind of thing that you find out a year from now somebody stopped getting the requisite requests. So make sure that you are, especially in the beginning, auditing it very heavily, and then once you have a comfort level that it is being done, you can relax a little bit, but I would still from time to time be making sure that this is happening appropriately. Now we're going to get into some fun scenarios. This is an example that came about last year for anybody who maybe follows the NFL. There was a player who was visiting South Florida over the 4th of July, and there was an incident with fireworks. And the reason why this got into the media was the fact that there was a police report because they were called to the site of the injury, and it was just known that there was a player who had an injury, but the details had not been released. And so having this happen right before fantasy football season, everybody was taking an interest. What was going to happen? Would this player be able to play? Was he going to have some sort of season-ending injury? Coaches from his team were flown down to Florida to try to see them, and they were turned away. So there was all this mystery surrounding what was happening with this particular player. Well, there was an employee from Jackson Memorial Hospital who decided to end all of the speculation for the good folks who were taking an interest, and decided to take pictures of the patient's medical records. And he sent them to a reporter for ESPN. And this became obviously a very big deal. And I am not kidding you when I say if you had turned on ESPN that night, it was literally showing you the EMR from Jackson Memorial Hospital. So in this situation, the player did lose his finger, and it's become a very, very big deal. At this point in time, the hospital has fired 2 employees that they were able to track, and the Office of Civil Rights is still investigating this. In addition to that, the NFL player is suing ESPN as well as a hospital for the privacy issues related to this. So we'll see how this all unfolds. These things can take time, but I do expect that we will hear a result out of this one. And some of the key points to think about from this is, so the hospital, in order to determine who the employee was that was going into these records, they had to run audit trails. Anybody who has an EMR has the ability to run those audit trails, and it'll show you which of your employees are going into which patients. What are they doing while they're in that patient's file? That's something that's very important. If you are not running those audit trails on a regular basis, I highly recommend it. It is something that is required under HIPAA, and it doesn't mean that you're always going to find something. The Office of Civil Rights just wants you to show that you are actively looking. So that's something that really becomes important in these situations where you potentially have a breach or an investigation. If you have people who are accessing information they should not be, think about how you would track that down. How would you try to figure out what was going on? So this was obviously a very high-profile case that happened related to social media, but I now want to give you a case that I came into contact with over the summer. That is, again, a local client we got a call from. And the administrator called me in a panic. He had a biller who had used Snapchat to share a patient photo with their coworkers. They thought that there was something funny about the driver's license, the scan that had been taken. So they took a picture of that up on their screen and then put some comments around it. One of the employees who received the picture had taken it to the administrator and shown it to him. In this situation, the biller was fired. But it created an interesting situation for us as far as having to go about and figure out whether or not this was a breach. One of the things that we had to do was determine how Snapchat works. This is one of those things where, as I said, technology can be fun, makes things easy, but sometimes it's too easy, and sometimes there are not ways to keep up with it. In this situation, we had to figure out, was that picture that had been sent out, had it only been sent to other employees, which, don't get me wrong, is still bad behavior, but would have made a difference from the perspective of if these employees already had access to that patient's information versus having that information shared outside of the entity with other people who might follow this person on Snapchat. But originally when Snapchat came out, the picture would show up for a few seconds and then go away and it was gone forever. That's not the way that that technology still works. So we are having to go through that process and figure out how much information was out there. Could we determine where the picture went? And all of those things, and whether or not we were going to have to contact Snapchat to help us get that information. So there are a lot of steps that go with this. And one of the things that happened here, so the practice did end up firing the biller, not a problem, but one of the things that as we were going through their corrective action plan is talk about policies and whether or not they needed to have a policy about staff using their cell phones at their desks. And as it turned out, this practice actually already had a policy in place about cell phone use in the office. Staff were only to be using their cell phones at break and at lunch. They were not to be using them at their workstations. So here we had a situation where the practice actually had a policy and was not following it. Now, there's no investigation that's going with this, but this was very eye-opening to them. This could have been very, very bad for them, where they wouldn't have even had a policy to stand on saying, you know, oh, we've trained our staff, they're not to use their cell phones, or they're not to use PHI in this manner. They actually had a really good policy that's stricter than is even required, but they weren't following it. And that's where that's something that could be held against the practice, because not only do you have to have policies, you need to be following them. So here I would ask you, do you have policies about PHI on devices? Again, I've got practices that for a number of different reasons do. Some of them take pictures. So dermatology practices are maybe trying to keep track of rashes or acne or something of that nature with the skin, and they'll take pictures so that they can upload them to the record. But you need to think about, how are these things being taken? How is that information getting shared? And whose devices are being used? Do you have policies on social media? So this is a situation where the person was using that patient's information not for any business-related purpose, but for their own entertainment. Have you talked to your staff about what's appropriate as far as using social media? Because I do know that I have employees who get contacted by patients via Facebook who want to be friends. And I've had employees who will ask me, is that okay? I can't tell people that they can't be friends with somebody on Facebook, but I can tell them that there should not be any medical communications going on through Facebook. It's not appropriate to be saying, hey, it was great seeing you in the office today. We're looking forward to seeing you next time. It's not appropriate to have the patient asking for medical advice via Facebook. So you want to be very, very careful that your employees understand what is and is not appropriate about using social media. And that includes not using patient information for social media. We've had employees who've gotten in trouble for posting pictures where they were participating in a procedure. They wanted to show off to their friends, not thinking about the fact that they had an unconscious patient in the background of that picture. So sometimes people just don't think about what they're doing and how they need to make sure that they're protecting information. Another thought on social media is your patients have social media. So you want to be thinking about that when they're in your office. What can they see? If they're taking pictures showing people that they're at the doctor, are they inadvertently taking pictures of your PHI in the background? So you want to be very, very careful and think about whether or not you have policies that address this and whether you have trained your staff. Because I guarantee you this practice never thought they were ever going to have to tell somebody that they couldn't Snapchat a patient photo, which would seem obvious, but that's the situation they found themselves in. They had to sit down, all of their staff, after this situation happened and have these discussions so that they could make sure that should this ever happen again, they can show that they trained all of their staff, that they're now making sure they're following that policy about cell phone use in the office, the actions that they're taking to try to curb that from ever happening again. And this is really important because I talk to a lot of practices and I'll ask them, when was the last time you had training with staff? And they'll say, oh, it might have been when the HIPAA rules first came out. HIPAA came out in 2003, so that's a long time ago. But also I'll have people who will tell me, well, my staff's been working in healthcare, for years and years and years. There's nothing they don't know about HIPAA. Believe me when I say people always have questions about HIPAA. And that's one of the reasons why you want to make sure you're doing training on a regular basis. Because people also have a tendency to forget. It's not always malicious. It may just be that they're encountering situations that they have never come into before, and so they don't know what the proper action is to take. And that's one of the reasons why you want to make sure that your training is current, but also so that as your staff changes, you know that everybody has been trained on your policies. But you also want to think about, have you trained your staff on the appropriate use of PHI? As I said, there are things that people have assumed would go without saying. As I said, who would think that you'd have to tell somebody you cannot Snapchat patient information? But nonetheless, that's the world that we live in. You want to make sure that you can always point to a training or something where you've been with your staff and said, patient information is to be used for treatment purposes only. Remember, HIPAA has a minimum necessary standard, which means you should only be dealing with patient information in regards to the patients you're actually working on. If I'm working in a practice, and this has happened to a practice locally, there was a celebrity who came in, and it quickly spread like wildfire through the practice that this person had come into the office. Suddenly, everybody was logging into the EMR and looking the person up to see where they lived locally, were they married, any information that they could derive from the medical record. That is absolutely inappropriate. It doesn't matter that you work for the practice. If you don't have a reason to be in that patient's medical record, you do not belong in there. At no time are patient records for our own amusement, and that's whether, in this situation it was a celebrity, but the same is also true if it just happens to be a patient that you know. Saying, oh, you saw a neighbor in the waiting room, oh, I hope they're okay, let me look at their record. Absolutely not. You need to make sure that people are only accessing records for patients that they're actively involved with, whether that's from a treatment perspective, billing, whatever the case may be. And as I said before, you want to make sure that you have ways to audit who is accessing PHI. The next situation, this wasn't one of ours, but it's a big settlement that came out of the Office of Civil Rights not that long ago, where the group was fined for $25,000. They had to come up with a corrective action plan and report on their compliance for a one-year period with the Office of Civil Rights. They were accused of failing to reasonably safeguard PHI, improperly disclosing PHI without an authorization, and that they had failed to implement policies and procedures with respect to PHI. And so you're thinking, what on earth did they do? And this is something that we actually hear come up quite frequently. They were taking testimonials from their patients and putting it on their Facebook walls. What happened was, it was a PT practice, and at the end of treatment, patients were asked to fill out a survey that dealt with the care that they received, their results, things of that nature. But when the patients were doing it, it was under the assumption that this information was staying between them and the practice. What they did not know is that the practice was then taking statements that had been made in those forms and putting them on Facebook, and if they had pictures of the patient, including those as well, which obviously made some patients very, very unhappy. So the Office of Civil Rights came in and, as you can see, fined them. But this is something, as I said, we hear come up a lot. People are looking for new ways to get more business and marketing and using social media tools. So you can use statements by patients, but you want to make sure that you have a signed authorization that includes what that testimonial will be, how you intend to share it. And never assume that a patient is okay with you sharing their information just because they were happy with your services. I've got people who will want to take out quotes from a little greeting card that the patient sent them. Or I've had practices where they treat famous athletes and they'll have the athlete sign something and then they want to display it in the waiting room or something of that nature. Make sure if you're going to intend to use anything for marketing purposes that you have that person's permission. Because me just telling you how grateful I am for the great care that I received is not the same as me consenting to you sharing that with the world. So you want to be very, very careful. And make sure that anything you intend to use, the patient understands exactly how you're going to use it. Are you just using their quote? Are you going to use their full name? Are you going to include a picture so that they understand exactly what they're signing up for if you're asking to use this information? And then we're going to talk about business associates. This is a big, big deal. This is anybody from a practice where if you're sharing your patient information outside of the entity. So these are going to be people like your shredding company, if you've got outside billing. My consulting firm, we do a lot of chart audits for practices. So we are a business associate because we are given patient information when we're doing those chart audits. Anybody that you're sharing PHI with outside of your practice, you need to have a business associate agreement in place. And in this particular case, the Office of Civil Rights initiated a breach investigation about an unencrypted, remember I talked about encryption earlier, laptop that was stolen from a business associate's locked vehicle. And in this situation, it was determined that there was no business associate agreement in place between this particular employee or the company that they worked for and the hospital. This was a big hospital system up in Minnesota, and that the organization had failed to do a system-wide security risk assessment. So in this situation, they received a penalty of $1.5 million. I want to emphasize, $1.5 million. So this is a big deal. The government is taking this very, very seriously. And so what the two issues here were is, one, that they didn't have that risk analysis and that they didn't have people trained on how to access PHI. So for your business associate agreements, make sure that you have them with anybody who's handling your PHI that you're paying for. Make sure that your agreements are current and they reflect your relationship as it exists now, because sometimes these relationships change. So that was a big reason that they got slapped, was because there wasn't even an agreement between these two entities showing that the business associate was agreeing to protect that PHI that was given to it by the hospital system. But the really big thing, and this is something that comes up all of the time, is make sure you have a security risk analysis. This is required under the HIPAA rules, so it's something you're just supposed to have anyway. But for any of you that are participating in meaningful use, this is also required under meaningful use. So you're also attesting to the government every year that you have this and you've been doing it. So it's really, really important. This is another area, like I said, where you can get in trouble under more than one entity for the same behavior. And this is supposed to be reviewed at least yearly, but it may need to be done more frequently if you have changes to your practice that may change your risk. You change EMRs, you get a new office space, something like that, where you would want to update this sooner than whenever you're due for your yearly. And for anything that you have in that risk assessment, you want to make sure that you can defend your answers when you're identifying a risk area. For instance, my providers who have PHI that reside on their mobile devices, some of them will tell me, I'm not going to encrypt my phone. How do you justify that behavior? Particularly for all of these smartphones, they now come with the encryption built right into it. It's not something that you're having to pay for. It's right there, and all you have to do is turn it on. You want to think about those kinds of things when you're going through that security risk analysis, because that's your opportunity to decide whether you're going to take corrective action or you're going to leave that risk there. But it is really, really important for you to think about those things and make sure that you're comfortable with what your answers would be should you ever be investigated. So my takeaway for all of this is, A complaint by one patient, as I mentioned, with the patient who was upset about the cost of their medical records, was just as powerful as a breach of hundreds of patients, because we heard about that one from the Office of Civil Rights before we've even heard about our provider who lost over 100 medical records. Never assume that something goes without saying, and that's really where we're talking about training your staff. Never assume that just because somebody has worked in a medical practice before they get to you, that they already know HIPAA. The examples that I've given you today, for those of you who are in Florida, as I said, almost all of those came from local clients. These are employees who are doing things that you would hope they would never do. That's your employment pool right there. And many of them were fired and went out looking for jobs in the area. So I want you to be aware of the fact that don't ever assume that people know the proper behavior to be taking, and that's why it's really incumbent on you to make sure that you are training people and that you have policies in place to protect yourself. And look around your office now. Is there anything you would not want to defend? Don't wait for that breach to happen or that complaint to happen before you take a look around your office and start looking at maybe where are your problem areas or what is the weakness. Look around now and see if there's anything that you should change before it becomes a problem. Also review your policies. Always review it from the perspective of an audit. Would you feel confident handing your policies that you currently have over to somebody? Would you be confident that you're actually following that policy? Or is it a policy that you will have being read for the first time in many, many years? And that's why I said that at the beginning. I've gotten into practices and they'll tell me, yep, we have HIPAA policies, and they'll point to it on a shelf, and it's a book that's still sitting in cellophane that's never been opened. I guarantee you they're not following those policies because nobody knows what's actually in that book. As I said, when was the last time you trained your staff on your policies? Don't assume because you told somebody 7 years ago that they couldn't throw PHI in the garbage can that they still remember that. That's why that annual training is really something you want to make sure you're keeping up with so that you can show that your staff has been trained and you are on top of making sure everybody is aware of the requirements. And finally, audit your own policies and workflow to make sure that they match. And so what that means is if you have a policy about medical records requests and who's in charge and how those things should be happening, go and follow the flow. Make sure that those things are happening. If you have documents you've got patients filling out when they're in your office, make sure that they're ending up in the chart. Make sure that your policy matches your workflow. If they don't, you need to decide which one needs to change. If your workflow is better now, update the policy. But if the workflow is something where people have started, that means you need to retrain and make sure that people are adhering to your policies. And with that, I'm going to turn it over to Tom.
Thank you, Catherine, and that was really some great and informative tools and resources for our discussion today. And it all boils down to, as you just stated, protecting your patient's information. What I'm going to talk to you briefly about, very briefly about, is protecting your practice. And most of you on this phone call today and part of this webinar are with physicians that carry professional liability, or what we like to call malpractice insurance. Currently, most of the carriers out there in our world carry what we call woefully inadequate coverage for these type of incidents where you have cyber or data breach, privacy breach, etc. So it's just as important with all of those tools and resources that Catherine spoke to you about to have the backup protection for when something like this happens. And you notice I didn't say if, because it's pretty much a matter of time with the amount of breaches that we're seeing that something can happen. And quite frankly, the coverage that you see on your physician's policy is very inadequate. It's typically $25,000 to $50,000. With defense coverages, it doesn't have a broad and comprehensive coverage for many of the things that Catherine was speaking of. And so you really need to look into updating that coverage. Many of the companies offer through their vendors, their insurance vendors that they team up with, additional coverage, higher limits, which, even for a small practice, we recommend $1 million in coverage for this because these claims get very expensive. Catherine mentioned to you some examples with fines and penalties, and that's just part of it, the fines and penalties. The other expenses, as we will tell you, and I won't go through them all today, but You're talking about notifying all of the patients. You're talking about credit, checking back and having credit companies come in for protection to review credit for all of the affected parties. You're talking about attorneys. You're talking about all kinds of IT people to come in and get information back and clear it. So as you can imagine from what I just mentioned, it gets extremely expensive. So these policies currently that you can get either through the malpractice company or in a standalone policy that we offer right now are very reasonable, and they're a fraction of your physician malpractice insurance, and they'll have much more comprehensive coverage and much higher limits, which we really recommend. Catherine had mentioned one thing, the security risk analysis. We're starting to see carriers ask about this on applications. So if you're applying for the cyber privacy coverage, you may get asked to see if you are doing and performing security risk analysis. If not, you are going to greatly limit yourself to the options you'll have for this coverage. So my recommendation, and that's one of the reasons we team up with Catherine and Acevedo Consulting, is to use their firm to perform these security risk analysis. Very important. So moving on to the next phase of this, everyone that's on this phone call is here because you're informed and you're concerned about this stuff. Some of the things real quickly that would be covered in this type of insurance, Catherine, if you want to move that slide, please, are right in front of you on the slide. And if you're only on the phone, you've got the claims made by clients and employees, regulatory procedures, which obviously HIPAA, fines and penalties related to privacy laws. Those are the HIPAA fines and penalties, which as we've seen, get very large. Cost to notify affected individuals, cost to restore your data, computer programs, damages, etc. Business interruption. A lot of people don't even think of that. If you have a major breach, you're going to have business interruption. It could potentially shut your practice down for days or weeks, which is not good for a practice. So you're going to want to have that coverage. And then there can be coverage in there for loss of money due to hacking. That's one of the newer coverages that we're seeing. This coverage is a moving target because of how intricate the communication systems and computers are becoming in social media. So we're seeing these coverages change over time, but it's good to get in now while the rates are still reasonable and you can have this valuable protection. So with that being said, we'll move it on to the question portion of this because I'm sure a bunch of you have questions.
Yeah, there's actually quite a few in the queue, so I'm going to try to get through as many of these. First and foremost, yes, everyone will be getting copies of the slides as well as the presentation. So I know we had a few people asking about that. So one of the first questions is, in a small solo practice with doctor and wife as office manager, who should be the compliance officer and who the HIPAA officer? No other qualified staff with time for these duties or aptitude.
So in that situation, and I do have a lot of practices that I work with where that's the setup that they've got is, it's the doctor and a spouse, and then maybe one or two staff people. There's nothing wrong with the provider or their spouse if they feel that they can handle those duties, fitting in those roles. It's just really important that somebody is putting on that hat. I do have people who will tell me, you know what, we really don't have time for HIPAA. It's not really important to us. As you can see from some of the stories I've told today, it is important. It has to be because of the fines and penalties that go with this, because the Office of Civil Rights is not going to, cut you a break because you were a smaller practice. They do still expect that you will have HIPAA policies and somebody adhering to them. But what I would suggest, this comes up all of the time where somebody will say, well, we don't have time to learn what we're supposed to be. You can hire people who can help you with this. There are plenty of vendors out there, including ourselves, who help people develop their programs or go in and do the training for them based on their policy. So you just kind of have to decide. And I know it's not fun to have to pay people to provide these services, but you just kind of have to make that decision whether you want to try and do it on your own, or if you want to have that outside assistance. But like I said, it's never going to be an option just to say, you know what, we were too busy and we didn't want to spend the money to have somebody else do it. You just kind of have to find a way, to make it happen.
Okay. Another question is, what is the threshold for encryption? Is this just a password to limit access to a PC or phone, or do you need another password to enter the PHI?
So for encryption, there are different standards. So some of the phones that we now have, the smartphones, I believe Apple is one of them, where once you turn on the password on the phone, it is encrypting the device. There are other devices. Jean in our office used to have the BlackBerry. I know on that it was a two-step process where just turning on the password on the phone was not actually encrypting the device. So that's going to be on a device-by-device basis. You would need to look up the manual for the particular phone that you have and check what the steps are for encryption on that particular device.
Okay. Let's see. In a small solo practice, no, we've already got that one. What if it is office policy not to share records via email, but patient insists? Can office then ask patient for their either snail mail address or let the patient pick it up in person?
So you have to have a couple of options available for the patient. And as I said, this year the Office of Civil Rights has taken a really big interest in patient access to their records. And they've basically come out and said that if the patient's requesting their records via email, that there really is no reason you should not be able to comply. So what that means is that if you don't currently have a system in place to email, you really should think about it. And like I said, you can have it be really restricted where one person in the practice has that ability to email records, where you may not necessarily be advertising that's what you do, but you do allow it, because you do have to follow those rules, as I said earlier, about making sure the patient understands that there are issues, that it's not a secured form of communication, but as long as they're signing off and telling you they understand and that's how they want to receive the records, you can send them that way. Because we had plenty of practices when the rules changed about 2 years ago. At that time, the Office of Civil Rights just said you could. So we had practices who said, you know what, our policy is nobody's emailing patient records. We're just not doing it. But based on the guidance that came out at the beginning of this year regarding patient access, the Office of Civil Rights has been pretty clear about the fact that they don't think that there's any reason why practices would not allow this. So you do have to have your restrictions in place and make sure that you're making it as safe as possible. For some practices, they've said, you know what, we're still not comfortable with the concept of unsecured email. So if they had the ability to set up encrypted email, they did. And that way, they never had to worry about what the patient was doing it with the email on their end. Or for others, like I said, they created a corporate email. They've restricted it, they're auditing it, and making sure that at least it's being done in the safest way possible, even if that's still not what they would choose to be doing. But like I said, unfortunately at this point, the Office of Civil Rights has been pretty clear about the fact that they expect that if this is truly the way the patient wants to receive their records, that you would comply.
Okay, and then our last question, if a potential breach happens, is the first step contacting OCR? Is there a form to fill out, or is there a procedure to this?
Okay, sure. So the steps are, once you have a breach, and under the new HIPAA rules, that's the default. You're assuming you have a breach until you can prove that you do not. Before, you went the other way. Nothing was a breach until you found enough elements. But the Office of Civil Rights was finding that, oddly enough, nobody ever got to a breach. So in 2013, when they updated the rules, they flipped the presumption, and now you have a breach unless you can prove otherwise. So your first steps when you think that you have a potential breach are going to be to investigate. And this is another thing that you should have a policy on that would dictate how you handle this situation. So one of the things that you would be doing is trying to track down the information. What type of information was involved? This may be a situation where we've got people who reach out to us to try to help them. The client that I mentioned who lost all of his records while on vacation, he had never been a client of ours, but he had gotten our name from somebody and hired us to go in and help him go through this process. So we helped him figure out which patients were involved and help him write the letters and the things like that that they needed to do to respond. You have up into 60 days after the year in which the breach is found to notify the Office of Civil Rights. So it's not something where you have to do it immediately unless the breach impacts over 500 people. At that point, you are doing an immediate notification to the Office of Civil Rights and the media and things like that. But for smaller things, you have, like I said, up to 60 days after the year in which the breach is discovered. You still want to try to do it in a fairly timely manner so that you are doing it while things are fresh in your mind. But I highly suggest waiting until you've notified your patients and sort of come up with your corrective action plan so that you can include that when you are notifying the Office of Civil Rights of the breach. There is a website. If you go to the Office of Civil Rights, there is a link that you can click on for notifying them of a breach. There's two different ones, one for under 500 patients involved and one for over 500 patients involved. And it's a fairly simple form. I mean, it's just going to ask you for information about the practice, name, phone numbers, address, contact for somebody to follow up on the situation. And then it will ask you for very basic details about what happened, how many patients were involved, and that kind of thing. But as Tom mentioned, there's a lot that can go into these investigations, and that's why he was giving you all of those examples of what those policies cover, so that you have those things to think about. If you have to hire somebody to come in and help you, in our situation, it wasn't an IT situation, but if there was a loss of a laptop or something like that, you're hiring IT people to come in. In a situation that I had with the briefcase, one of the things that did happen is as we were trying to track down the patients that were involved, is we had to contact the hospitals to get them to help us recreate this information because they had the other copy. But when we contacted one of the hospitals, they would not help us because this doctor was so far behind in his dictation. So we had to bench him for a couple of days so he could get caught up on all of this old dictation so that the hospital would help us because we had a very limited amount of time to get all of this figured out. So that's why it's really important, as Tom mentioned, there are all kinds of things that go into this. There may be other people that you need to have come in and help you. So you really want to be making sure that you are cognizant of what goes on. And in Florida, for those of you that are in Florida, you only have 30 days to notify the patient of a breach of their information. And 30 days can sound like a really long time, but as I said, with my briefcase scenario, we had more than enough hurdles to try to go through and get cooperation from all of the hospitals involved and figuring out how much information was involved by each hospital so that we could write letters to our patients so that they would know very specifically what might have been compromised for them. And then once we had resolved all of those situations, sent out all of the letters, retrained all of the staff, and done what we needed to do for them, then we went through that process of notifying the Office of Civil Rights so that we really could kind of put a bow on it for them and let them know that we had handled it to the best of our ability and hope that that would help that particular situation.
Okay, great. All right, everyone, thank you so much for joining this webinar. If you have additional questions, you can reach out to Tom or Catherine. As I mentioned, you'll be getting copies of the slides and a copy of the webinar within the next 24, 48 hours, and we appreciate it. Thanks for joining us on your lunch hour.
Thank you, everybody.